Good morning, everyone. We're happy that you could join us this morning. I think we're going to give a few minutes just for everyone to enter the room. So we'll allow everyone to get settled. Thanks for joining. Okay, good morning, everyone. We're happy to have you here with us. Thank you so much for joining us this morning. Our Calibra team, as well as our partners, which I'll introduce in just a few moments, are welcoming you to the Jamaica Data Protection Act, DPA compliance, and readiness for companies and organizations, which we know you're very eager to hear a little bit more about. We have with us this morning our partners. I'm very happy to introduce Calibra, who is the hosting team that's here today, Hart, Muirhead, and Fatta, and Data Privacy and Security Advisors, DPSA, and the Jamaica Stock Exchange eCampus team. So before I hand over to the speakers, I'd just like to introduce them and give a little bit more about who they are and what they can do for you. Mr. George White is the Managing Director of Calibra Solutions. George has a host of experience that spans an excess of 25 years in information security, a host of IT leadership experience. So we welcome George this morning. Presenting as well from the partner, Hart, Muirhead, and Fatta, is Ms. Justine Collins. Justine has an interest in financial technology, data protection, and electronic commercial. She's a member of the Jamaican Bar Association and is also a lecturer in data protection at the Jamaica Stock Exchange campus, the eCampus. Happy as well to welcome Mr. James Coons. James has a wealth of experience that spans 30 years in information security, data protection, systems management, and a host of other items. In addition to enjoying photography, James also commands a comprehensive understanding of the broad legal framework that the government and the Data Protection Act are expecting. We also have joined with us Ms. Shanique Gray. Shanique is an eCampus recruiter at the Jamaica Stock Exchange eCampus faculty. So I'll hand right over to Mr. George White, who will introduce himself a little better and also start the proceedings. George?
Thank you, Natalie. Pleasure to join. While I share my screen. Thanks, everyone, for joining today. As Natalie pointed out, Calibra, we've been around in operation for over 15 years. We bring a lot of experience. While our key area of focus is information security, we also provide other solutions, but of course, our focus today is going to be on data protection, data privacy, that component of information security in which you're interested. So my approach today is to quickly go through an overview of Calibra Solutions Limited, what we do as a company. I'll speak a little bit about compliance, data privacy / data protection, non-compliance business risks, and our value proposition in terms of how can we assist you We have a pending deadline approaching, but the idea is that there's no need to panic. We're here, we give you the assurance that we can assist and support you to get things done and to meet your organization's objectives. So I'm going to go through a few slides very quickly, and what I could do is share the content at a later date, maybe via email, if required, so we don't spend a lot of time in this particular activity. So our head office is in TNT, but we have a broad team of employees and consulting team members across Trinidad and Tobago, Jamaica, and the USA. And we're a regional company. We have clients spread across most of the English-speaking Caribbean, and also non-English-speaking territories, Dutch Caribbean, and the Spanish Caribbean. In terms of what we do broadly as a company, our value propositions around information security, maybe three main elements: cyber resilience, dark web intelligence, and trust intelligence, which is the area of focus this morning. We're also an analytics solution provider, providing enterprise business intelligence and analytics for companies across the region. In terms of our solutions, and I'll go quickly through this as promised, our main partners in this space are Darktrace, Threat Intelligence, Searchlight Cyber, Dark Web Intelligence, OneTrust, who provides a broad range of what we call trust intelligence solutions, including data protection, and our partner, our experienced partner who brings a lot of value in the space, data privacy and security advisors. On the analytics side, we're a business partner for Click, data integration and data analytics software provider, Mimics financial application software, and internally, we also give more wealth of experience, provide IT consulting and advisory services. I mentioned earlier OneTrust and the Trust Intelligence platform. This is, I would say, all-encompassing, covering a wide range of capabilities and functionalities within the space, from privacy, data governance, risk and compliance, and ESG, and various other components of this type of technology, including third-party risk. Talking quickly about Click as our business analytics platform. Click is a well-used, very popular platform with about 40,000 clients globally, and is a leading cloud provider in the space. In terms of our customers, this slide looks at our customers across different business sectors. Most of them fall within the financial services space, but of course, in terms of what we do, it's not limited to any particular business sector. Now, in terms of our focus this morning, data protection, this slide sort of explores what is data protection all about. And we've sort of provided a little distinction between privacy and data protection. In the privacy definition, it's really about everyone having the right to respect for his or her private and family life, home and correspondence, anything related to individual's privacy. And data protection, as it indicated, is that there's a framework in which data privacy can be enforced, and this is the foundation behind the Jamaica legislation. And of course, we should point out that this is not restricted to Jamaica as a country. It's a global phenomenon. A lot of the groundwork was done in the European Union with GDPR. In the US, while it's not federally mandated at this stage, many states are moving to implement privacy provisions, California, New York, and various other states. In terms of compliance, of course, we're going at a very high level here. Our subject matter experts will go into the nitty-gritty details and provide a lot more context and content of the subject matter as we go further into the program. So compliance is really about the proper handling of customer data while adhering to data protection laws, regulations, and best practices. And of course, it's important because it protects individuals, prevents data breaches, and of course, non-compliance can result in harsh penalties, but a lot more than just a punitive financial penalty. It can affect a company's reputation and various other negative implications. So, compliance framework, we're looking to advise and assure and assist you in ensuring that there's a good framework that guarantees compliance. It means having an overall compliance strategy, having experts to advise you, and some knowledge transfer so you can continue on the journey ad infinitum. And various other bullet points indicated there that, as I indicated, our team will delve more into the nitty-gritty details. So we're asking the question, why does data privacy matter? And these are just a few points as indicated here. It's about caring. We need to care about protecting people's personal information. Additionally, it's an opportunity to make privacy central to what we do. And thirdly, by not handling personal data properly, we could put individuals at risk and the organization's reputation, of course. This next slide looks at the results of a survey which indicates that companies take the issue of privacy seriously. They have a privacy policy in place, and there are some positives in terms of what has evolved, but of course, there's a lot more to be done to take us to where we ought to be. What are some of the non-compliance business risks? And this slide sort of illustrates just a few of them. One of them is that your clients may decide not to do business with you if they're not sure about how the personal information is being used or will be used. Secondly, your company may be subject to litigation. And of course, that has significant financial implications. And the third bullet point, which encompasses several things, we're talking about damage to your brand, your reputation, your customer loyalty and satisfaction, market position, shareholder and affecting the bottom line also. Now, in terms of DPSA and Calibra, one of the things that we did as a company is that we brought together a number of partners who bring tremendous value to the space. And we're talking about DPSA, our partner, which has its foundation in the US, but they have done tremendous work across the globe in various countries where privacy is being implemented. So we're bringing together a team with extremely strong compliance strategy expertise. We've also done it before in other jurisdictions: GDPR, CCPA, HIPAA, GLBA, LGPD, and of course, with that collective experience in many other countries doing this many times before, we bring tremendous expertise to assist the Jamaican organizations to make the transition a lot easier. So we're talking about tremendous privacy, technology agnostic expertise, certified talent pool, and of course, a broad range of service offerings, which James will outline in more detail as we go further into the program. This brings me to the end of my presentation. Thanks again for joining. And I'll turn you over to the next presenter. Thank you.
Thanks, George, for that wealth of information. Before we move on, we just like to shoot out a poll question, and we'd like to remind everyone that you're free to put your responses in the chat or to raise your hand, however you'd like to handle this. So our first poll question is, how familiar are you with the specific requirements of the Jamaican Data Protection Act? And it's on your screen, and you can go right ahead and complete that poll. So we'll give everyone a few minutes just to get that in. And it's just a reminder, it was such a timely reminder when I heard our partner, James Coons from the DPSA say, yes, the time is up, the time is ready, law is ready, but guess what? It's the right thing to do. So let's go ahead and let's fill out the poll. Few more seconds. Sure that everyone is eager to fill this poll out. So the first question, how familiar are you with the specific requirements of the Data Protection Act? It's one choice, it's multiple choice. The first is very familiar. The second is somewhat familiar. The third is not familiar at all. So you can go right ahead and make your selection. Now I'd like to welcome from the Jamaica Stock Exchange faculty, Shanique Gray. So Shanique, welcome. We are so happy that you're here with us today.
Good morning, everyone. So happy to be here. Thank you for your warm welcome. So my job today is to let you know a little bit about our eCampus and what it is that we do. One of the courses that we are going to be discussing today is our postgraduate certificate in compliance and information governance, which is going to be predominantly speaking about our data protection course. Our postgraduate compliance and information governance has our data protection course, anti-money laundering and compliance and company compliance and management administration, and our information governance and security principles course. So one of the things that we are trying to push towards is having persons have a better understanding of data protection and data privacy and how it is that it's going to affect organizations and what will be entailed in everything that we do. The course lasts for 4 to 6 weeks. It's going to be starting October 22nd. The cost for this course is $65,000 plus GCT and registration fee of $2,500. Although persons can register to do the full program, we are trying to allow persons to be able to do the data protection course. So it is that they are ready for the December 1st deadline. So we'll have persons who are, readily equipped to take on what is needed for the new roles. The faculty for this is Miss Justine Collins, and you'll hear a little bit more about her as we go on, and she'll definitely be able to tell you what it is that we're going to be going through and discussing and having a better understanding of the Data Protection Act, so to speak. One of the reasons why this is so important for us to get done is because of all the changes that have happened and how it is that we need to be prepared and ready. in order to take on these different roles. And we look forward to anyone who is interested in getting onto this course and want to know a little bit more about us. And it's online completely for those persons who are not located here. You can do it at any time. We also have it recorded as well. So if it's a case where you miss a class, you are able to jump on and go through the information as seamlessly as possible. So thank you so much for your time. And if it is that you have any questions on our courses, you can reach us at JSCE campus, or you can call us at the number that's listed on the screen. Thank you so much.
Thank you so much, Shanique. I'm sure there was a wealth of information in there that was very applicable to all of our audience. And any information that we have to share will be shared with you post-webinar. So our second poll question, if I could go to that, I'd like to ask, which requirements of the Jamaican Data Protection Act concern you the most? What really keeps you up at night regarding the Data Protection Act? What is really bothersome to you? For me to deep dive a little as well. The selections are, so the question is, which requirements of the Jamaica Data Protection Act concerns you the most? Selections are building a privacy program. That's the first. Website notice and internal policies. That's the second. The third is conducting required data protection impact assessments. The fourth is vendor risk management. The fifth is registration with the Information Commissioner. Or, of course, you can select all of the above. And we'd like to remind you there's really no wrong and right. It's really what's applicable to you. So we'd love to have your responses to get a feel of the audience, to get an idea of where things are, and to make sure everyone is doing the right thing. Thank you. I'll give you a few seconds. Okay, so I'm seeing from the responses, which of course are anonymous unless you want to tell us, from your responses that most people are concerned with every item that we've identified in the poll. So that's quite interesting. We'll give you a few minutes again just to see if everyone can get their responses in. And I believe I have the honor of now handing over to Ms. Justine Collins of Hart, Muirhead and Fatta. Ms. Collins, such a pleasure to have you with us. So happy you could join with us again. This is not our first time, so our relationship is definitely working. So we'd like to welcome you. Thank you.
Thank you so much for having me. I really appreciate Calibra, Natalie, Gracia, George, everybody having me here. It's always a pleasure to be with you guys on a Wednesday morning to just talk about all things data protection and compliance. So I'm not gonna be too long, but I just wanna speak about data protection in terms of the legal aspect of it. And of course, George touched on a number of things and gave us a sort of broad overview of the landscape. And thanks as well to Shanique and the stock exchange for speaking about that course that we're going to be embarking on in a couple weeks. Data protection, the Data Protection Act, we are moving full speed ahead towards compliance come December 1. And so it's very important for companies and organizations to know their requirements and not only know what's legally required, but also how to comply. The practical implementation is important, and I know James will walk us through that. So today I will just go through very quickly the Data Protection Act in terms of the legal aspects under Jamaican law. We're going to be looking at key definitions, the standards, some of the rights, regulatory oversight, what it looks like in terms of appointing a data protection officer, penalties, the GDPR, and I will kind of do a little segue for James to take over in terms of building that privacy program. So key definitions, what are we looking at? What is this? What is it all about? And what does personal data mean? And personal data is the reason we are here. Personal data can mean information, however you store it, relating to a living individual or an individual who's been deceased for less than 30 years, who can be identified from that information alone or from information and other information in the possession or likely to come in the possession of that data controller. So we're looking at the name. Is it somebody's name? Is it somebody's TRN? Of course, a TRN, a taxpayer registration number, it's just a string of numbers. But once you actually look in a database and the data controller says, okay, that number relates to Justine Collins, that is personal data, you know? So either information which by itself identifies the person or along with other information that the controller has, identifies the person. Now let's look at sensitive personal data. So sensitive personal data can be anything from biometric data, your blood type, your health data, your affiliation, your racial origin, philosophical beliefs, political opinions, your physical or mental health, any allegations of a crime. All of that information is something that we consider sensitive personal data. And the distinction is important because how you lawfully process that data will then be determined by whether it is just personal data or whether it's sensitive personal data. Now, the data subject, what does that mean? Who are we talking about? And that's that named or otherwise identifiable individual who's the subject of the personal data. So we're talking about me, Justine Collins, that I'm a data subject. Natalie's a data subject. We're all data subjects here. So we are all individuals and we are the persons who are the subject of personal data. And the whole point of the regime is to protect our information as data subjects. And processing, also very, very simple, but very important. It can be anything from obtaining data, organizing data, consulting it, disclosing it. And so a lot of times when we go to companies and we talk about how they process data and they say, we don't do anything with it. It's just there in a database. And sometimes we kind of check on it and we don't do much more than that, but that might be processing. And so you have to be careful in terms of analyzing what activities you're doing in relation to the personal data. And data controller, what does that mean? We talk about it quite a bit. Now that data controller can either be a natural person, i.e. me or you or Natalie or George or Gracia, or it could be a legal person like a company, like a partnership. So it can be a legal entity or a government agency who either alone or jointly determines the purpose and the manner. So very important because this is distinct from a data processor. A data processor will process data on behalf of the controller. All of our obligations under the Act really accrue to the data controller. The data processor is sort of like an agent of the controller. The data processor processes data on behalf of the controller and is not an employee. So the fact that you have an IT department or a CIO or somebody within your organization who is responsible for certain activities during the course of their employment, they won't be a processor, they will just be your representative as a controller. But if you hire another company outside of your organization to do some processing on behalf of you as a controller, that entity may be viewed as a processor. So we're just jumping ahead to the data protection standards. And now we have 8 data protection standards. And the first one is fair and lawful processing. This really speaks to what's your legal basis for processing your data. We talk a lot about consent, but there are more than just, it's not just consent. You can also be looking at legitimate interests. You can be looking at whether or not you're statutorily required to process data. Right now, we're in Jamaica, we're under a lot of changes in terms of beneficial owners and disclosures and making sure we know who our customers are. A lot of legislative changes, and persons are now having to make sure that they know who the persons are behind these organizations. That kind of disclosure is required by law. And so that could be a lawful basis for you processing data. Purpose limitation. You want to make sure that you're collecting this data for one or more specified purposes. Data minimization is a standard as well as a tool in terms of ensuring that you're not collecting more data than is necessary for the processing. So if you're going to go to a wholesale and you're going to buy just some snacks, why would you need my TRN for that? You know, is that necessary? Is that relevant? Is it adequate? No, probably not. You're not doing a transaction with the government. You're not paying taxes. So I don't know why I need a TRN for a cheese tricks. You know what I mean? So those are the things you have to look at. Accuracy. Are you keeping it up to date? Is it accurate? The data, that is. Storage limitation. Are we storing it are we storing it longer than is necessary? And compliance. Are we complying with all of the other obligations under the Act? Security, are we keeping it safe and secure? And of course, George and the Calibra team is very, very versed in terms of information security. And then the final standard is data transfer. So we want to make sure that when you're transferring data outside of the jurisdiction, it is in accordance with the rules in the Act. So I spoke kind of briefly about this slide in terms of the bases for processing data. So there are a number of bases. We talked about consent. It's usually the buzzword when we're talking in the data protection space, but it can be one of many, right? So it can also be processing is necessary for a contract. So if you have a contract and you need certain information in order to fulfill that contract, that would be a lawful reason for processing the data. We spoke about legal obligations, which the data controller may be subject, and as well as the functions of government. And of course, if it is that you have published the information online, as a lot of people are doing nowadays, that would also be a lawful basis for a controller processing the data. So jumping right ahead to some of our rights. The rights of the data subject. And we have a couple of rights that really assist us in terms of ensuring that our data is kept safe, and of course, that the controllers observe these rights, right? So we have a right of access. And this right of access allows you as a data subject to go in and say, hey, I want to know what kind of data you're processing about me. So can you just give me an overview of what you're processing? And of course, this is going to require on the controller's part, a level of operationalizing. How do you actually do that? Are you going to, do you know where you're keeping your data? And is it that it's going to be by a form? Is it an electronic process? Is it manual? And so it does, even though you have this legal obligation, you do need to think about how you're going to practically implement it. How are you going to do that? And I think that James can kind of give you some guidance in terms of the how of data protection. consent is required for direct marketing. So any kind of text messages that you're getting straight to your phone, emails that you're getting straight to your email, those are what we call direct marketing, where you're directly contacting the person. That's going to require consent. In terms of a right to prevent processing of personal data likely to cause substantial damage or substantial distress, that really relates to whether or not there's some processing of personal data that's going to cause harm in terms of emotional distress and possibly physical harm. In terms of rights in relation to automated decision-making, as you know, nowadays, AI is everywhere. AI might be with us right now in this Zoom. We never know, because you know that some persons send their AI assistants to Zoom meetings. So in relation to automated decision-making, you need to ensure that the logic behind that decision-making is accessible to the data subjects. And of course, a right to request rectification of inaccuracies. If there's any inaccurate information that a controller has about you, you want to make sure that the persons are able to say, hey, you actually have my name spelled incorrectly, or you have some information about me that is not correct. In terms of regulatory oversight, which I think is a very buzzy topic right now, the Information Commissioner's Office has been established. They are building out that office. Miss Celia Barclay, who's an attorney at law, is the Information Commissioner, and they have been doing a really good job in terms of providing public notices. They have a very active social media presence. So if you don't follow them on LinkedIn, I would encourage you to do so, because a lot of the notices that we're getting right now are coming from that page. But essentially, she's required under the Act to monitor compliance under the Act. She maintains a register of data controllers. She disseminates information about good practices. And we're certainly seeing that in terms of recently, I think even what consists of large scale processing and different kinds of terms. She's been very helpful in terms of disseminating information and clarifying things. There's also certain regulatory powers in terms of a power to issue assessment notices, information notices, all of these tools designed to see whether or not you as a controller are compliant with the data protection standards. Now, in terms of registration, which is a big ticket item. Now, since we last met, I think we had our last webinar a couple months ago, there have been some draft regulations which have come out, which are being reviewed as we speak. And I believe that they are in the consultation process and supposed to be tabled soon. So registration, as I understand from a public notice that was sent last week, Sunday, I believe, registration will be happening on December 1. And as I understand it, registration will open on December 1. So we are awaiting the final regulations in terms of how registration is going to go, what it will entail. And so once we do have that information, of course, I'm sure the Information Commissioner's Office will let us know. And so right now we do have some draft regulations that are in the process of review. Now, what we know of registration under the Act is that it will entail the disclosure of the name of the data controller, the purpose of your processing, and it speaks to also what type of data you'll be processing, etc. And so you would then need to have an understanding of what kind of data you're processing and the purposes. So certainly some sort of data inventory exercise, if you haven't started, that would probably need to go on. There's an annual fee, which we will find out about soon, hopefully. And of course, if you do not register as a data controller, it can constitute an offense and possibly an $1 million Jamaican dollar fine. All right, in terms of appointments of data protection officers, so under Section 20 of the Act, it speaks to the requirement for an appropriately qualified person to be appointed to monitor in an independent manner the data controller's compliance under the Act. Now, this person can be an employee, or it can be an agent employed on a contractual basis. But the important distinction is that that person cannot have a conflict of interest between their duties as a data protection officer and any other duties. And if you think about it, remember that there is a sort of reporting obligation that data protection officers have in terms of if the controller has been contravening the Act and they haven't, the officer has said, hey, this is the situation, and they haven't really done anything about it, there's an obligation to then report to the Information Commissioner. So certainly that conflict of interest situation that may arise, that would require you to not be in a position of conflict. So if you're an employee or even an agent or somebody outside, conflicts are important. It's certainly required if you're a public authority or if you process sensitive personal data or process data on a large scale. Just to give you a broad understanding, and this is actually coming from, this slide is actually coming from the Information Commissioner's Office themselves. These are the sort of broad roles that an DPO will perform. They ensure that the controller processes personal data in compliance with the Act. There's consultation with the Information Commissioner, assisting in submitting that data protection impact assessment report, data breach management, which is very, very important, and monitoring compliance with the Act. As you know, under the Act, you have 72 hours within which, if you do have a data breach, to notify the Information Commissioner's Office, and your data protection officer is going to play an important role in that. And so just to also reiterate that some of the things that you need to consider in terms of appointing your data protection officer is familiarity and access, if they have legal knowledge and or specialized privacy training. So there's a number of courses out there. Of course, the Stock Exchange, eCampus, we've been working on this course from before the Act was passed. So it is a good course. We've worked on it from, I think the bill was tabled. So it's been the longest course in Jamaica, for sure. There are a number of data protection courses in Jamaica, but they were the first. And so I think that they have a really good program, and I would encourage you to speak with Shanique or anybody from the Stock Exchange about that course. And certainly you'd want somebody who has audit or compliance experience to be the DPO, technical skills and independence, and of course, excellent communication skills. Just going to go briefly through the penalties because I am running out of time, but I know I don't like to be the bearer of bad news. When I get to this slide, I'm always like, yeah, there are penalties. So, we have to try and be compliant, but there is a compliance risk if you don't act within a certain period of time. I know a lot of people are saying, okay, let's wait and see. But the wait and see approach isn't necessarily a good approach, especially when you look at some of the penalties that we're possibly facing. So a company may be liable to a fine not exceeding 4% of annual gross worldwide turnover. And so that's a whole lot of money. I mean, 4% of your gross worldwide turnover is quite a bit of, it's quite a staggering fine, but it aligns with what we're seeing internationally in terms of some of the fines coming out of these data protection regulations. If that offense is committed with the connivance or neglect of a director, manager, secretary, or company, that person may also be punished. So there's a possibility of personal liability. So if you say, oh, let's wait and see, but you can also personally be liable, I think that would kind of require you to act with some alacrity. And then, of course, there's a possibility of facing a civil suit in terms of a person suing you, a data subject suing the company for any loss that they may experience. Just going very briefly over the GDPR. I think George would have mentioned it briefly. So the General Data Protection Regulation, or GDPR, that's coming out of the European Union. It entered into force in 2016 and was made binding in law by 2018 now. What's important for us is the fact that there is an extraterritorial effect. So there are some provisions, if it is that you are found to be offering goods or services to persons in the EU, you could also be subject to the GDPR. So you do need to do an assessment to see whether or not your business operations can be said to be either offering goods or services to persons in the EU or monitoring persons in the EU's behavior. So definitely have to think about that as well. And then if there are any international data transfers, you'd want to ensure that it conforms with the various rules under the GDPR. And I am just going to finalize this by doing a little segue into what James might be jumping into. But here are some critical questions you should ask yourself when you're thinking about building your privacy program. Does your organization properly define your privacy risks? So we talked about even the GDPR, like, are you aware of the privacy risks that face your organization? Is there a GDPR or EU component or UK component to it? Have you actually assessed and see, okay, is there somebody within our organization who is going to be our privacy officer or data protection officer? Do we understand the gaps in privacy management? Do we monitor privacy management? Are employees properly trained? Very, very important. And then even if there are quite some organizations who have done the policies and they have it, but then the employees don't know about it. So they don't know what's in the policy. And that's always a bad thing when you have a policy and you're like, man, we did a policy years ago and employees are like, huh, there's a policy? I didn't know that. And so very important to keep up with training. Do you follow best practices for data inventories, risk assessments, and privacy impact assessments or data protection impact assessment? Do you have an incident response plan? Very important. When an incident happens, sometimes it's almost like a storm or an earthquake. It's a similar type of situation, and you don't want to be running around and be like, oh my gosh, what are we going to do? Do you have a plan? Do you communicate privacy-related matters and update the materials as needed? And finally, does the organization use a common language to address and manage cybersecurity risk or information security risk based on business and organizational needs? Just as a high-level overview, these are some of the policies or procedures that you might need to consider in terms of data protection and compliance. You can start with a data protection policy, but in terms of some of the other procedures, you may need a procedure in terms of managing third-party service contracts. Those entities might be data processors, and so you need a procedure to say, okay, how are we ensuring that we have sufficient contractual guarantees within those agreements? Incident data breach incident plan is important. Oops, sorry. Your data retention policy, data sharing agreements, of course, very, very important. Consent mechanism, and of course, for employees, because remember that even if you're an organization that's primarily manufacturing and you don't necessarily deal with a lot of customer-facing data, most companies do have employees, and so your employees their privacy needs need to be respected as well. So I think that's it for me. If you have any questions, feel free to jump in the Q&A, or you can give me an email. Thank you very much.
Thank you so much, Justine. A wealth of information from Justine Collins there. And as she would have said, we're not going to be getting ready, we're going to be ready. So with that, I'd like to hand over. Before we do though, we have one poll question again. Has your organization appointed anyone, any human, as a person to lead privacy initiatives? So we'd like to get your feedback on that. The first answer is yes, that's me. The second is it will be shared by multiple teams. And the third is no, not yet. If it's no, not yet, what are we waiting on? Okay, and with that, we'll give you a few seconds again just to complete that poll, and I'd hand right over to Mr. James Coons, who's going to dive into a demonstration on instant, as he would have said this morning, on the OneTrust platform, which really shows you the kinds of things that you could be doing to be able to be compliant, to ensure your compliance and your organizations and your staff's safety. So I'll hand right over to Mr. James Coons.
Hello, everyone. Thank you for joining. This is a lot. We know it's a lot. And so the question now is, where do we begin? What do we do? Right. So we do this for a lot of organizations. So I'll say in theater. So companies that are located in Jamaica. We haven't done very many, but we now have double digits of our US clients that we are actually conducting these assessments against the Data Protection Act for, because they either have they're processing data of residents, or they have some sort of business interest there or presence there. So those are the US-based businesses, and we've seen this with the GDPR. My organization, we've conducted literally thousands of different assessments, as George said in the beginning. Anything from GDPR, even some financial stuff like the GLBA. In the medical world, we do HIPAA and high-tech assessments. So really, across the board, impact assessments, maturity assessments, readiness assessments. We even do ISO certification and readiness programs there as well. So with all of that, talking about the Data Protection Act, the looming date, it's coming. We know it's coming. Where do we begin? So what I thought I would show you today is what we would do if you came to us and said, okay, Calibra and DPSA, I need help. I need you to assess my organization and provide me with my gaps, and then help me resolve that, right? And so that's what we do. And what I'll do is I'm going to share my screen. Instead of showing you a slideshow, what I want to actually show you are three different things. And number one, I'm going to show you the OneTrust platform. So this is what's commonly referred to as privacy technology. And so it is a software platform. It is a SaaS solution hosted in the cloud, which organizations can license on their own. Or if you have, for example, Calibra and DPSA do the assessment for you, we provide that, and that's bundled in there. So there's no licensing that you would need to do. So I want to share that with you and kind of show you what that looks like, because that's a little bit behind the scenes. And then moving from there, I'll show you what we call a findings grid. So that's where we take the results of the assessment and we put it into a proprietary grid format that DPSA has created in order to come up with a roadmap. And then finally, I'm going to take you into Microsoft Word and show you an example of what an executive report would look like. So the findings grid and the deliverable being those things that you would receive as a result of such an engagement, and then just initially OneTrust, kind of what's powering that. So with that, I'm going to try and share my screen, and hopefully everyone can see can see my screen. So this is what it looks like when I log in to OneTrust. Again, this is a special demo instance of the software. I'm not going to spend too much time in here, but I do want to show you this. If you're licensing this on your own, obviously you wouldn't have the Calibra and DPSA logo. You could place your own there. OneTrust is very, very configurable. It is highly configurable. You can change just about every aspect of the software to fit your needs. I will show you this screen that shows you just a kind of overview of all of the applications that OneTrust has. So you can do more than just assessments. Justine mentioned a lot of these things. You can do data mapping. That's going to be huge for the Data Protection Act. You can also handle consents, right? So cookie consent and even email consent, universal consent can be handled by this platform. If your company's interested in ESG program reporting, it can do that. You can do ethics. You can have an ethics hotline. You can do risk and incident management, both for IT and for the organization as a whole. Another thing very important, and I've got my mouse over it right now, very important for the Data Protection Act, this can automate your PIAs and DPIAs, and we do a ton of those. Again, literally thousands. Right over on the other side, privacy rights automation. What is that? Remember Justine talking about individuals having the right to know what information you're processing it, how you're processing it, who has access. This is automation of that. In summary, again, very super powerful platform. The little piece that I'm going to show you today is called they call it the PIA and DPIA automation module. And basically, this is where you do assessments. And it is not limited to a PIA or DPIA. You can literally do any sort of assessment. You could even do an assessment to gauge how happy your employees are. It doesn't necessarily have to be privacy or data protection related. What's powerful, though, is that you can build workflows and build in frameworks into these assessments. So that's kind of what we've done. I want to show you kind of behind the scenes. As you see here, we have a number, and this is a demo instance. So for demonstration purposes, this isn't as crowded as what an actual instance would look like. But today we're talking about the Data Protection Act, and what you see here, we actually have a more current version of an assessment for that Data Protection Act. You can kind of see that it's broken down in different sections. You have a scope section, you have a section asking questions about a data protection officer. Basically, we custom make this. We'll do a little bit of research. We'll have a kickoff call with the organization. We'll learn about them, and then we'll fine tune this to kind of fit their vertical, to kind of fit the size and the scope. Companies of all sizes, whether you're 25,000 employees or 25 employees, it doesn't matter. We have something that'll fit your need, and the deliverables you get at the end will look the same. They'll just be in line with the size and scope of your organization. So I'm going to open a couple of these, and you'll see kind of different symbols here. These indicate whether or not, you see a little red asterisk, you see some of these. There's logic that are in these questions, and that's kind of what that means. So depending on how these questions are answered, it might trigger another question, or it might eliminate some other questions, right? So that's what this looks like. And what we would do is we would set this up, and then we would send it out to different departments in your organization. So we'd say, okay, we're going to send one to your executive management. So you pick somebody there that could answer questions. We're going to send it to human resources. We're going to send it to sales, marketing, operations, whatever departments you have in your organization. It might be 5, it might be 50. We send this out, and then all of the results will come back in. It goes out. The folks get an email. They get a URL. They click on it. They can answer a few questions. They can leave for the day and come back and pick right up where they left off. It's going to send reminders. It does all of that fancy stuff for you. And then at the end, I'm sorry, I'm going to have to look on my other screen. I want to do a new share here, and I want to show you what we do. So switching out of the, hopefully I did that right. We're going to try this again. Switching out of the OneTrust platform, now I'm in Excel. And I hope everyone can see this. It might look really small, but I really don't need you to read anything here because it's all, just for the purpose of demonstration, but it is based on our actual findings grid template. What you see here is the section. So we saw those sections in OneTrust. We see the question. And then over here, you see the different respondents. So respondent 1, 2, and that's management, IT. Yeah, I forgot to mention IT, HR, accounting, operations, sales. We have all of that. And then their answers, right? And we see a bunch of different things and colors here, and they all mean something. Quickly, CON means conforming. So the answer that they gave conforms with the regulation that we're doing the assessment. So you see all of their responses, and then you see an assessed response, and then recommendations. And then you'll see a level of effort and risk as well, right? And interesting about this is if I want to see how accounting, or let's say I want to see how marketing answered the questions, I can click on that and I can see all of marketing's comments. I can see all of marketing's answers to the question. I can see a little bit more information inside of that. So this is what we call our findings grid. And this is where we start to put together the real picture of an organization's readiness for whatever we're assessing them against. And in this case, it's the Data Protection Act 2020. We call it the JDPA, or the Jamaican Data Protection Act. It's not really the real name, but because we deal with so many different pieces of legislation, this is what we do. We also have another one of these, and it will do both the GDPR and the JDPA, as well as we have templates that will do multi-regulation. We just did one for American Airlines that was global, right? It covered literally every single piece of privacy legislation that is enforceable. So that was pretty big and took a lot of time. So we'd move on from that grid into what we call a final or executive report. And I hope everyone can see this now. So this is now in Microsoft Word. This is what a final report would look like. And for those of you that can read it, it's really small down in the corner. You see that it's 65 pages long, and that's huge, right? So I want to kind of walk through it. It does come with a table of contents. So as I said before, if you're 5 employees or 5,000 or 50,000, you get the same thing, right? Yours might not be quite as long, but it's going to have the same components. You're going to get an executive summary. You're going to get a quick overview of the Data Protection Act, or whatever it is that we're assessing against. You're going to get the findings overview. So we're going to take that grid and we're going to, highlight what we found out of there. And I'll show you all this. And then we're going to give you a roadmap to compliance, a project overview, which kind of talks about the methodology that we used and, how we approached, and then phases that you can take with your findings. And we actually, in that findings, we actually give you actionable items to work on, right? Obviously, that's something that we do as an organization and can help with, but some companies want to do it on their own, and that's okay. So we give you a starting point. And then we give you the full findings grid, right? And break that down. So you'll see that's broken down by certain things, privacy management, your notice, your choice and consent, all of those things. And then you get the appendices, you'll get the findings grid, which is that Excel file. And for the JDPA, since it's so closely aligned with the GDPR, we give you a quick GDPR overview. And when I say quick, it's a couple of pages. And then we give you a comprehensive overview of the JDPA, which you see here starts on page 50 and ends on page 65. So that's a little bit more in depth. I'm going to quickly scroll through the report. Again, this is based on a real report. The names have been changed to protect the innocent, but this is actually from a real US-based company. So this is kind of what you get. You get, like I said, a quick overview of the JDPA. It's going to talk about kind of some of the highlights. It's going to talk about people that we've assessed. It's going to talk about how to manage a privacy program and start getting that off the ground. Then we get into the findings overview, right? We talk about at a high level what your most pressing things are. We're going to highlight that. Then we're going to, you know, kind of break each one of those down for the, you know, different areas. If you're doing business, this company actually had some interests outside of Jamaica, so we added that as well. And if that's your company's situation, you would get the same. Going down here, we talk about everything from vendor management to your security and breach notification. We're going to talk about how you can manage your privacy risks. We're going to give you this roadmap to compliance. And this is where the fun begins. So this is your prioritization chart, and it's going to give you your high risk gaps, your moderate risk, and your low risk. And it's going to break that down for you in terms of where the reference is, the level of risk, the level of effort, and an estimated time frame. Now, that estimated time frame, we provide that, and that's based on empirical knowledge that we have of doing thousands of these, and at this point it has been thousands. So you know, it's going to vary, but it does give your organization kind of an idea of how long things might take. We give you a prioritization matrix, and we list everything out in that matrix, and then we'll give you a benchmarking roadmap, right? We can change these dates, you know, break it out by quarter. And again, as I said, you get that project overview with phases. We'll give you a quick comparison to other organizations, right? Again, this is just kind of across the board empirical knowledge, but it kind of helps you know where you stack up against others. Any caveats and limitations, you know, I am an attorney, but I'm not practicing, and I'm certainly not practicing in Jamaica. So, you know, those kind of things are disclosed in this report. Then we'll go into excuse me, the detailed findings grid. We give you all of that information, right? So all of the responses. And then again, as I said, the GDPR overview, again, this is a very quick, see, it's not even 2 pages. It's maybe one and a quarter, but then the JDPA, or the Data Protection Act, this is a comprehensive overview. It's going to have links to the actual text of the act, where the Government of Jamaica publishes, you know, that's linked here. It's broken down. You get the scope, you get the material scope, all the key definitions we broke apart, so you don't have to sit there and read the 123 or whatever pages of the act. We break down the most important points for you. We highlight the principles in here for you. Any obligations that controllers and processors have, we break that down for you. Going on, we'll talk about, you know, the DPO and the stipulations for the appointment of the DPO. We do provide references, so you can look in the Data Protection Act in Section 20, Paragraph 3. You can learn more about this paraphrasing. That's throughout. You'll notice that's throughout here. Data breach notification, data retention, you know, minor data, special categories, all of that is broken down in here. The other big thing here, the data subject rights, that's all part of this report. And then, of course, as Justine ended hers, you know, with the penalties being 4%. So yeah, it's a very comprehensive report. As part of our engagement, you know, we would have a session with you and your organization where we would go through the findings here, and speak with you about these and what they mean. And, you know, we'll talk about the remediation information that we've provided, you know, and have a very large Q&A session, right? Because we've been through this with the GDPR. We're going through it now with the Data Protection Act in Jamaica. We've been through it in Canada with PIPEDA, with the Australian privacy principles. We've done this around the world. The concept is not new. The Data Protection Act has certain derogations where it strays from the GDPR, We've created a crosswalk for that. So we talk about that with you as well, where the Data Protection Act is closely aligned with the GDPR, where it's moderately aligned, and where there's full derogation. And so we can work with you on that. So it's a very valuable instrument. Reports like this, are used to be only available if you hired a big consulting company that is going to charge you hundreds of thousands of dollars. A report like this and findings like this, an assessment like this, is attainable literally from those organizations, from 5 people all the way up to 50,000 to 500,000 employees. There's something for everyone, and I think that's the main thing I want to impart. Given what George spoke about initially, and then what Justine spoke about, it's very scary. It seems like there's a lot, and there is a lot that should not be underestimated, but there is a way to start tackling this and become compliant. So with that, I want to leave time for questions. I know I flew through there, so I'm more than happy to answer any questions anybody may have. I think we'll hand it back to Natalie.
Thanks so much, James. A wealth of information. Again, the most salient point that would have stuck out to me is fines. I'm sure none of us want to be paying any fines, so let's get ready to be ready. We have one more poll question before we go into our question and answer segment. Our poll question is, how ready is your organization? How ready are you for this? Give you a couple of seconds to answer that. It's not a hard one. And then we'll go straight into our question and answer segment, which will be answered real time by Ms. Justine Collins and the rest of the panel where she needs our support. So how ready are we? How ready are organizations? The first option is we are compliant. The second, somewhat prepared. The third, not prepared. And the fourth, unsure. And there is no wrong answer. I remind you of that. We're here to help you through this process. Okay, so most people are somewhat prepared. We can help you with the rest of the somewhat. So let's go into our question and answer segment with George, Justine, James. I'm not sure if Shanique is still on, but the entire team is on to filter questions. You can please send your questions directly into us, and you can look at the chat to get your answers. So let's go.
And again, we realize this is an awful lot of information to take in. I think the feedback that I get the most from organizations is that they just really don't know where to begin. They know that they have certain components, but they just don't know where to begin.
Understood, James, understood. It is a wealth of information, so I'm sure that there are questions, though, or we can start to tackle anything that anyone has internally that may benefit the wider audience.
I think Latoya Henry has a great question about appointment of a data protection officer in the chat, in the QA.
Hi, everybody. Thanks so much, Latoya, for that question. I hope everybody's seeing me. Okay, great. That's actually a very good question. So what we're seeing, I don't want to speak definitively because we're seeing some preliminary guidance coming out of the data protection regulations, but I would say in terms of the act itself, what you really want to look at is whether or not that person has a conflict. So you want to look at the role of the person. So if they're in-house counsel, or if they're compliance, or what type of function they have internally, if you're engaging an employee, you want to see what their job description is and whether or not there's a potential for a conflict situation to happen, particularly when there's a breach. One of the things that I actually think is very, very helpful is that we have some guidance coming out of the European Data Protection Board. And so we're looking a lot at the international best practices in terms of determining what constitutes a position of conflict. So really and truly, what you need to look at is that person's role within the organization, and see whether or not, if there's a situation where there's not only an incident breach, but even just a data protection standard breach or any kind of issue from a data protection point of view, if they as an employee would have that role would then conflict. So for example, if you're looking at in-house counsel, normally as a lawyer, you're advising the company as to how to mitigate risk. And so it might be a little counterintuitive in a sense for you to have your in-house counsel as data protection officer. Not to say that some companies don't have it and it's not fine, because sometimes they might engage external counsel and then, you know, that conflict situation doesn't necessarily arise. But it really is not a one size fits all. It depends on that person's specific role, their job description, and their reporting obligations as well, because the data protection officer ideally should be reporting to the board of directors. So a CEO, for example, without a doubt would probably be in a position of conflict when you look at an incident that's happening, because if it is that you have that reporting obligation to the information commissioner and you are the CEO, you would then basically be required to tell on yourself in a sense. So certainly there is some guidance in terms of what might be a conflict, but it really depends. So what you would start with is you start with the act, and you start with the guidance that's coming out of the Information Commissioner's Office. Look at some of the things coming out of the international best practices. Article 29 Working Party has been dissolved, but you know, we have EDPB and there's some guidance there. And look to see whether or not that person has certain responsibilities in their job description that could potentially be in conflict with that role. I think you have another question here. The idea I'm getting is to ensure that there is no direct or foreseeable connection between the data protection officer as a reporting officer and the role of any person who would be responsible for addressing the breach by way of providing advice and or answering for the breach internally or to regulators. Yeah. That and of course that's a reasonable contemplation. You would have to look to see whether or not, okay, is it reasonably foreseeable that if we have an incident or even just an information notice or something where the ICO is asking you, are you in compliance? Is it reasonably foreseeable that that person would have a conflict? For if the person is the person who built out the program itself, generally speaking, that's a position of conflict, because when you are the data protection officer, you then need to sort of monitor that privacy program. So it is a subjective assessment in a sense where you have to look at that individual, their role, and see how best they can fulfill that role without it being in conflict with their existing role. I hope that helps. Go ahead.
And that's a great point. I just want to add. So for example, my company, we do not provide DPO services. We don't do it for the GDPR. We don't do it for the Data Protection Act, right? So it needs to be that truly independent individual acting individually within the organization, reporting to the highest levels. And I think I think that's the important thing to think about, right? As Justine said, right? So we saw this with the GDPR, right? We would go through the same thing. We would provide those reports, and that's the first question we would get. Okay, can you guys be our DPO? And we go, no. And I think that's, your question kind of embodies that, right? So there's, there's too much opportunity for conflict of interest, right? Because there's a saying in the US, everybody's baby's beautiful to them, right? So if I create your privacy program, that's going to be the best privacy program in the world, and whatever everyone else says is wrong, right? And that is definitely not the spirit of this type of legislation, right? So another really important aspect of this thing is, of any of these, like the GDPR or the JDPA, as I call it, is the DPO's different roles, right? We've written some job descriptions for companies with offices in Jamaica for a DPO, right? And while there are really no published guidelines, that's what we look for. We look for those things that Justine said, right? Like, you really need, if you're looking at appointing an individual that's already within the organization, right, you really have to pay attention to those reporting lines and that person's prior involvement in the privacy program or any compliance program, right? Because moving from there, they need to be part of consultation for things like DPIAs, breaches, and all of that, right? So you don't want to create a conflict of interest. A lot of our US companies that are going down this road are looking at hiring an outside individual because that makes it easy for them to bring somebody new in, kind of put them, dotted line at the top, so that they're avoiding a potential conflict of interest. And hopefully that answers your question, or at least gives you some insight into that aspect of the DPO.
Yes, James, I see we have some more questions in the chat. I'm going to throw it out, and anyone that can answer can feel free to. So where you outsource processing to a third party, such as an external counsel or an auditor or pension provider, would that third party be a data controller or a data processor? Typically, a data processor takes instruction from the data controller. However, with those types of third parties, are they really acting on the controller's instructions?
That's an excellent question. I can jump on that. So with any privacy legislation, usually at the very top, you'll find definitions, right? So there's clear definitions for what a processor is, what a controller is. With the GDPR, they introduced the concept of a joint controller. So we kind of still use that broadly. And while we don't specifically see that with the Data Protection Act per se, the concept still exists by virtue of that kind of role. But yeah, I mean, typically you're going to be a controller. When we look at that word, you're in control of the data, right? You're in control of what happens to it, how it's collected, what it's used for, whereas the processor is processing it and following the instructions of that controller. So the examples that you gave with a pension provider, or even like a outside counsel or consultant, right? If an organization provides me as a consultant with data, they're providing it to me under contract to have certain functions performed with that data, right? So in real world instance here, an organization in Jamaica might say, okay, James, here's some data. This is a list of all of the systems and vendors and clients that we have. I need you to assess the privacy impact given all of this information. That's all I can do with that data. I can't send all of those vendors an email saying, hey, would you like to hire me to do your impact assessment? Because I'm under specific instructions. I'm just a processor. I have no control over that data. So while there is the concept of a joint controller, those examples are still pretty cut and dry under the definitions within the act, right? An external DPO, great question. Is that a processor or a controller? Well, that's going to depend on the tasks that DPO performs, right? Generally, when you're a DPO, you're not necessarily processing much personal data at all, right? So when I do these assessments for organizations, I'm really just asking a lot of questions. I'm not looking at data. I don't have access to data. I don't have access to Salesforce or any other platforms that your business is using. I'm just asking questions of those who do, right? I'm asking questions about policies. I'm looking at those types of things. So generally, those roles at best could be considered a processor. Now, if I have to collect personal information in order to evaluate, compliance, then that could potentially change. But in general, that's not something we'd see a DPO or even an external consulting company or an external DPO becoming a controller.
James, the questions are coming in fast and furious.
Yes.
Happy to see that. So you're seeing this question here. What is the implication for the contract, depending on the category in which a third party falls?
So that's a great, great question, right? So the impact for the contract, right? So what we've seen over the years, especially since the rising of the GDPR and when that went through ascension, you had contracts, we call them many different things, sales agreements, service agreement, whatever it is, or you're basically your contract with your client or your customer, would always have a little bit of something in there about, hey, our systems are secure and things like that. And we saw that evolve into what we call DPAs, or data protection addendums or agreements even. So an addendum would be in addition to an existing contract. An agreement would be a separate contract that you're entering into, which covers data protection and compliance aspects, right? So those types of documents, either within a contract or as an addendum to a contract, they're going to define controller and they're going to define processor, and they're going to clearly state, hey, me, company A, I'm a controller, and you, company B, are a processor, and here are the rules. You agree to abide and demonstrate compliance with the Data Protection Act. I agree to demonstrate compliance with the Data Protection Act. Hey, if something bad happens, you agree to doing this. Hey, if something bad happens, I agree to doing that. So it definitely does mean a change in your contracts. You really want to make sure that the folks, the vendors, whoever you're doing business with, even clients, know about the act and can demonstrate compliance with the act, right? You also want to indemnify yourself if an egregious act on their end causes an incident or a breach, right? You don't want to take the fall. You want to have that all spelled out. So there's a definite impact on contracts. And then there's questions about HR, right? So HR has always been very interesting. So in respect to absences or vacations, would that require consent? Or is it justifiable to notify your staff for the operation of the company, right? I think it's okay to say James isn't going to be here today versus James isn't going to be here today because he's having a giant tumor removed from the top of his head, right? So we always look at how far do you need to go, right? Obviously, as an organization, HR is always going to have access to the more sensitive data, right? We know the naughty things that employees have done in the course of their employment. We may know things about their health, and not always because we've asked for them, right? I might email HR and say that, hey, I need to go have a colonoscopy. Nobody wants to know that, right? But by virtue of who HR is, a lot of times they see that data, right? So now it comes down to another point that Justine brought up earlier, and that's training and awareness, right? So how do we deal with that type of information, and what's the right thing to do? The right thing to do is to not talk about it and pass it on. Obviously, if we need that information, maybe I run a warehouse and people's physical health is important, right? Because we don't want them getting hurt doing something they shouldn't be doing. If I need to have that information, then consent can come into play, where I need that consent to have that information and process that information and obtain that information. But in the general course of business, where maybe we all work in an office, those things aren't as important. And if they are shared, it's important that we either have a process to destroy that information, and as Justine pointed out, having like the training and the awareness to know, like, this isn't something we talk about James behind his back in the lunchroom when he's not there, right? We respect that information and we kind of close it out right there, per se. So very good question. HR is always been that interesting enigma, just, you know, by virtue.
Thanks, James, for all of that information, that wealth of information. I know that, sorry about that. I know that we should be wrapping up now. We do have one more question that I'd just like to give for you to give an answer to, or maybe Justine can. That is with respect to the specific rule that the JSE course prepares any attendee for.
Yeah, I'll jump in there, and I think if Shanique is still here, she can also assist. So the JSE course. Oh, go ahead, Shanique. I'll defer to you.
Thanks, Shanique.
Go ahead with your question. Sorry.
What specific role does the JSE course prepare you for?
So anyone who is planning on taking the JSE data protection course, in terms of the whole program or certificate, so your data protection officers, you can actually apply for a data protection officer role. So if it's a case where you are looking to be a BDO officer within your organization, that gets you ready for it, because Justine will go through the whole series of the act, what is required for you to be a data protection officer, all the things in which you'd be required for you to uphold, who it is that you answer to, because as a BDO officer, you don't necessarily answer directly to a manager there. But who is it that you need to then give those information to? How is it that you stay on top of things? How is it that you prepare for a person's information? You'd also be given information on how it is that you would go through the process of collecting person's information, who it is that you're dealing with, how is it that you deal with when it is that you're dealing with persons from not just Jamaica, but internationally, how is it that you handle their information and so on. So the course would go through all that you would need as it relates to data.
Right. And just to support what Shanique is saying as well, what is important about the course is that it's customized for the Jamaican Act. And so a number of courses that are out there are based on other legislation. We would have heard about GDPR and other laws that are important to data protection. But what's very unique about the course is that it is customized for the Jamaican Data Protection Act. We start on October 22. It's very, very interactive. It is online. It's after work. So it's not disruptive to your day. And so it prepares you for either becoming a data protection officer or assisting your company in terms of building out your privacy program. And then, of course, if you decide to go with the entire suite, because I know that it's part of a larger certificate program, there are, of course, anti-money laundering courses and other compliance courses that could be helpful within your organization outside of data protection.
The first data protection course is face-to-face, so they all know that.
Yes. So the first one on the Sunday is we will meet in person and have a little chat. There will be food as well. So definitely looking forward to you guys signing up.
And those persons who are not in you can still join in on the course. We will have live streaming for those persons as well. So it doesn't hinder you if it is that you can't come face to face.
Okay, so we have taken up your entire morning. We're glad that we were able to do that though. We're glad that you've shared your time with us. We are encouraging everyone to complete our post-webinar survey. So it will pop up on your screen. We're asking you to complete that. But in closing, I'd like to thank all of our presenters, all of the teams, even our events team for coordinating this and getting everything done. For any further information on the Data Protection Act or any information that you'd like at all, you can feel free to email info@calibrasolutions.com. That's info@calibrasolutions.com. Or to learn more about the data protection, you can register for the data protection course by contacting Shanice Gray. Her email, shanique.gray@jamstockx.com. That's Shanique, SHANIQUE.gray, GRAY, @jamstockx.com. That's JAMSTOCKEX.com. So thanks to everyone for your attention, for even the questions. If your question was not filtered and answered today, you can feel free to email us and we can get on that, and definitely we're ready to get you compliant. So guys, thanks so much. Enjoy the rest of your day. Have a great rest of your afternoon. And thanks so much for joining the Calibra, DPSA and Hart Muirhead team. Thank you. Have a good day.